Hello everyone. This episode is on leave and license agreements. Before moving forward, please take a moment to read the disclaimer. Real estate, that is immovable property, has become one of the most valuable assets in the world, from a basic necessity such as residential use to commercial use. A four-wall structure provides a lot of value to its owners. There comes a time when we use these assets to make money. That is where the question arises as to whether, among other things, we want to sell, lease, or license the additional space that we have. So what is a leave and license? Well, it's a unique method of giving a space owned by one person referred to as the licensor to another person who is referred to as the licensee. These may be multiple people as well. In India, the Indian Easements Act, Maharashtra Rent Control Act, and Maharashtra Stamp Act are the primary sources of law on this topic. A license, simply put, is a permission granted to enter, exit, and re-enter the premises. This permission does not create any title and/or interest in favor of the licensee. It is distinct from a lease and/or a sale. The concept of a license is such that the possession of the premises is under the control of the licensor, and the licensor regulates the entry, exit, and re-entry of the licensee. The law in Maharashtra mandates that a license be in writing and duly registered. This obligation is casted on the licensor, that is, owner of the premises. Since the leave and license agreement generally includes transfer of money in exchange of the right to enter, exit, and re-enter the premises, there are many commercial components which require to be explored, negotiated, and duly considered by the parties. These include, but are not limited to, the following: term of license, monthly license fee, security deposit, lock-in period, due diligence, no possession, no assignment or transfer, assurances of parties, right to inspect, events leading to termination, termination notice, double license fee upon termination, securitization or financing, restoration of premises, no objection certificate, maintenance charges, board resolution, force majeure, arbitration or court, stamp duty, and registration charges. The clauses just mentioned by us are a few of the critical clauses which require to be thought of while drafting a leave and license agreement. Among other things, it should also be remembered that in cooperative societies, usually a no objection certificate is required to be obtained before giving a premises on leave and license basis. Once negotiated and drafted, the agreement requires to be finalized, after which stamp duty, registration charges, and document handling charges are required to be paid. And finally, an appointment with the Office of the Joint Sub-Registrars of Assurances be taken. These are to formally acknowledge execution of the document before the governmental authorities. Once these steps are completed, you have a duly executed and registered leave and license agreement. An interesting fact which is quite often overlooked in Maharashtra, where this particular law is applicable, is that as per Article 36A, the stamp duty on a leave and license agreement that is executed for a period longer than 5 years, with or without a renewal clause, is calculated as if the instrument was a lease deed, which means that the stamp duty would be a percentage of the market value of the property as opposed to being calculated on the license fee. A leave and license, once executed and registered, would finally run its course and come to an end over the time that is called termination by efflux of time. In such a case, where the validity of the document ends by itself, the licensor, that is the owner, generally is obligated to return the security deposit after making suitable reductions as per the agreement or mutual discussion between the parties, and the licensee simultaneously hands over the vacant charge of the premises. It is preferable to have this settlement and closure recorded in writing, duly signed by the parties. In the alternative, the agreement may require to be terminated for cause. Cause simply means for a reason. This reason could be an event such as breach of terms of the agreement. In such a case, the leave and license agreement must be terminated through another instrument, that is a cancellation deed, which is also to be registered. With that, we end this topic on leave and license. Stay tuned for more such videos. If you found this video informative, then please don't forget to subscribe and share this video.